Hi, my name is John Council. I'm a senior reporter with Texas Lawyer newspaper, and welcome to the July 18th, 2008 edition of Remanded. My guest today is George Milner. He is a partner in Dallas's Milner and Finn, and it really should be called Milners and Finn because your dad is also a partner there. George is a criminal defense lawyer, does a lot of DWI work, and I would like to talk to him a little bit about a proposed rule change to the Texas Administrative Code. And what this would do, George, would make it a lot easier for you to serve a subpoena on a police officer in what is called the automatic or administrative license revocation procedure, which happens when you get arrested for DWI. You don't give up the breath test. They can take their license away. If you want it back, you go through this hearing. And usually the motorist is represented by somebody like George. Now, George, there's a comment period on this till August the 3rd, and the comments so far from prosecutors are, we don't like this. And the reason I don't like this is because I think it's going to make the procedure like a mini trial, and you can trip up their police officers. So now, does that happen, and is there a reason to be concerned about this new rule?
It happens in a minority of cases. It is certainly something that is a viable concern to a prosecutor, but that concern should be based on the policeman changing his story. There's no fear unless we're going to get version A at the administrative hearing, we're going to get version B at the trial, which happens frequently. However, it's in the extreme minority of cases. Most policemen come down and you get version A, you get version B. Excuse me, you get the same story both times.
Yeah.
It's only in that situation where the policeman has sat down with the prosecutor, and the prosecutor inevitably has helped them remember things that they did not remember at the administrative hearing, and now you have these changes that the defense lawyer, someone like me, is going to capitalize on and elicit every prior inconsistent statement that was given in sworn testimony.
Now, since if the so-called red tape is cut in this procedure, it's easier for you to issue a subpoena. Does that give you more incentive to do that, or would you do that anyway?
Well, we do it anyway. I mean, in every one of these cases, we will issue a subpoena. It's simply filling out a form stating this was the officer who made the arrest. He has all personal knowledge relevant to what are essentially the two issues.
Right.
Do you have a lawful stop? Do you have a lawful arrest? Those are the contested issues. What this change will do is permit us to get the second officer. And that's not going to be in the majority of cases, but it will come up from time to time where one officer initiates the traffic stop, and a second officer makes the arrest.
Right.
Well, how do you cross-examine the arresting officer about the driving when he has no personal knowledge of the driving? And that's the reason for it. So this is, from the prosecutor's standpoint, much ado about nothing. I mean, we already get one officer. Now we're simply, when necessary, going to be able to get the second officer, because that will be the only officer who has first-hand knowledge, has personal knowledge of what is relevant to the first prong, which is, do we have a lawful stop?
So, all right. Last issue, George, is a decision from the Supreme Court, and it involves a dispute between an attorney and his client or former client over attorney's fees. And the attorney was trying to get back about $30,000 that he was allegedly not paid by his client. And this was litigated for 10 years. Now, the attorney finally won. But a question for you, George, is, would you do that? If you're owed $30,000, are you going to lay down and litigate?
Well, personally, for $30,000, I might pursue that a little bit, but somewhere between a few months and 10 years, I would have given up the fight. I would have said it's not worth it in the long run. They were pursuing $120,000 in
attorney's fees, as well for fighting for the initial 30.
Right. And so there's a little bit more to fight for there, but I suspect the man did it on principle.
Exactly, and I've done stories about lawyers who have sued clients, and generally that's the reason why they'll take that on is for the principle of the thing. And but every time I do that story, I talk to other lawyers and I ask them, "Would you do this?" And they're like, "No, it's just not worth it."
Yeah, personally, I would not do it. You just gotta let that go. You're going to spend more time in aggravation worrying about that when you've got other clients you need to take care of. At the same time, it's troubling, and there's not a lawyer out there who hasn't been stiffed on a fee at some point in time. And you sit there and think, I gave you 100%. I did my end of this bargain. Why are we now having some issue about whether or not I'm entitled to be paid exactly what you agreed to pay me? I mean, I didn't let you down on my service end. Why are you letting me down on the money end of this thing? We've got people we have to pay, and that sometimes clients don't realize this, but it's not just the lawyer, it's the office, the rent, the electricity, the staff, the insurance, all these things that enable us to be there to do the job in the first place, and those people have to be paid.
Yeah. All right, George, now it's time to put you in what I like to call the witness stand. I'm going to ask him some questions and see what George has to say. All right, first question, George. Since you're in a firm with your dad, what's it like working with a guy who yelled at you when you didn't take out the trash?
Well, I guess it's been so long since those days, it doesn't faze us. I will say that it is an extreme fortune that I have to be able to work side by side every day with my father. I mean, I can't brag about that enough. I mean, it's a true delight. At the same time, this is now a business colleague. This is a partner. You're in a professional relationship, and I've seen the other side of him. I can remember getting chewed out for all the things that people get chewed out for as they're growing up, and I can remember learning the art of cross-examination when I was in high school, and I was on the receiving end of his cross-examination about where have you been tonight and who you with and why did he not get home at the time you said you were going to get home. So I've seen it.
Yeah, all right. I wouldn't mess with George Miller Sr. myself. All right. George, have you ever taken a DWI client out for drinks after getting them acquitted?
That's actually very rare. It has happened. I can't say that it's never happened. I tell them, and I really try to emphasize this because I don't want anybody to ever go through that, and I sure don't want them to go through it twice. But I tell them, look, let's get a cab. Let's be careful and not jeopardize this. We used to joke around. We always appreciate when somebody has one for the road. It's good for our business, but I've always feel horrible for people when they have to go through it because it is not a small event in your life.
Okay. George, are you glad the Great Tomato Scare of 2008 is over?
I'm glad. I can get real hot sauce now, like what's the name of it is, as opposed to the imitation stuff I've been eating at the Mexican restaurants. All
right, last question. Shouldn't diminished capacity be an affirmative defense for just about everything?
That's probably true. I guess you think broadly, I guess you can come up with some situations where maybe it should not, but I think you're going to have to put at least a duty to raise it on the part of the defense, if not to affirmatively prove it by preponderance of the evidence. But certainly,
more along the lines of, well, the keys in my car, diminished capacity. Oh, I shouldn't be held accountable.
Well, as long as it doesn't go to the range of absurdity, certainly they're legitimate. I think when you get in that situation, being serious, I think a jury can see the difference. If this is some feigned, this is BS, this is not what we're talking about here, versus this really is a legitimate, this guy is not playing with a full deck, and we need to take that into consideration as we evaluate these facts.
That'd be me. Thanks, George.
Thank you.
Bye-bye.
Bye-bye.